does estate planning, so she'll be with us today to explain and answer any questions we have about that. Did you want to say a few things, Nicole?
Yeah, sure. So I have an estate planning practice here in Chicago, and I work with clients of small, medium, large estates. I really feel passionate about helping everybody get an estate plan together that meets their needs and goals. And I love working closely with clients to understand what are their needs and goals and to help put together a plan that really works for them.
Yeah. So what would be a good time, you think, to engage your services, before or after the divorce?
Well, great question. I would say if you are somebody who doesn't have an estate plan put together and you're wondering that same kind of question, when should I start thinking about putting an estate plan together? It might be helpful to know a little bit about, well, what happens if you don't have an estate plan?
Yeah.
And if you don't have an estate plan, then you're kind of subject to the default rules that operate in the state of Illinois. And essentially, let's say you are a married person and you have a couple of kids, which is me. If I die and I don't have...
Don't even say that.
Yeah, no, it's terrible to think about, but also important. And I'd rather use myself as an example than somebody else. But if something were to happen to me, then half of my assets would go to my spouse, which may be exactly what I want. But the other half go to my minor children. And that, might not be what I want, because they can't manage those assets. They actually can't even inherit those assets until they turn 18, at which point they'll get everything. And so if I'm married, if I have children, and I haven't yet even begun the divorce process, I want to put an estate plan together so that that kind of situation doesn't happen to me. If I'm thinking about a divorce, it's probably time to talk to an estate planning attorney as well, because you want to start thinking about, what if something happens to me mid-divorce? Do I want all of my assets or half of them naturally passing to my spouse? If I'm already ready to, call it quits. And so I am a firm believer that if you're, before a divorce, definitely after a divorce, it's a good time to put together an estate plan or revisit one after a divorce, for sure.
Yeah. We were talking last week, Jan, I don't think you were here, but with Jessica, about the case you took to Washington on appeal because the spouses, one ex-spouse and the wife, were fighting about the same thing, like a beneficiary form, right, Jan? Wasn't filled out properly?
Yeah, it was a military issue. So you had some forms that the military requires regarding survivor benefits, and it wasn't filled out properly. It wasn't executed completely. And it got really sticky, and it was very expensive to fix. Yeah.
Yeah. So tell me, was, so these this couple, apparently they got divorced, and then the beneficiary designation wasn't updated to reflect like the divorce decree or something?
Yeah, well, what happened was that the gentleman, he was a military member. He's active duty military member for quite a few years. He spent a career in the military, and he was married to the same woman for about 35 years. And she did receive his military retirement pay benefit that was divided. But there's an issue of the SBP, or the survivor benefit plan, who gets the survivor benefit once you pass away. And then he married somebody else, and he was married to her for about 7 years. And he made the designation to this person that I represented, and he was only married to for about 7 years. But the paperwork that the military requires to be sent in, he indicates it was sent in, it wasn't received, there was no confirmation. So it got real sticky, because when you're working with the federal guidelines and the federal laws related to what the requirements are under the military issues, it's really, there's no room for error. It's either you did it or you didn't, and you followed the directions, or you didn't follow the directions. So the fight was between the two ex-spouses who is going to get that retirement. And maybe in a situation when you have, Nicole, a retirement plan, let's say you go ahead, you're going through divorce. Sometimes the divorce lasts a year or two.
Yeah.
You have to redo it once the divorce is final, or can you draft something that lives through a divorce?
Well, so usually, there's usually an injunction from moving stuff out of your estate during the divorce, right? So you don't want to do anything there. But in terms of updating beneficiary designations and things like that, you want to have all your ducks in a row so that once the divorce is finalized, you have all the forms there ready so that you can update title, you can update ownership, just so it aligns perfectly with that divorce decree. And if you're working with an estate planning attorney, that's something that they can, hold your hand with and make sure that that you don't run into those sticky situations like with these special forms that need to be filled out precisely, because that's what we deal with day in and day out when it comes to putting a trust together and funding it correctly and things like that. So
what's the benefit of a trust versus a will?
Yeah, great question. So, I like to analogize our stuff that we carry through, like that we hold and we own in our lives, as though it's in this imaginary kind of like crappy bucket. And that bucket.
Wait, what?
And that bucket.
Crappy.
Because at our death, it just like breaks down. And all that stuff is spilled out. And someone needs to be there to pick up all the pieces and arrange them so that they go to all the right people and do it quickly before, the mortgage comes due or the insurance policy needs to be paid, etc. But when you are putting a trust together, you are essentially investing in a really nice stainless steel bucket. And everything you own, you're now going to place it, take it out of your old decrepit bucket and put it into this really nice bucket. And so when you die and that old bucket spills out, there's nothing in there. It doesn't matter. And everything that's in that nice stainless steel bucket has someone else now in charge of it. So if you have little kids, instead of thinking, oh shoot, now they're homeowners, or now they own my car, or now they, have all this money to account for, there's just someone else in charge of it that you trust to hold on to it and manage it for their benefit. It also helps you avoid, or helps your loved ones avoid having to go through the probate process, that's the judicial process, in order to administer this estate upon your death, in order to retitle all these assets. It's already been retitled. It's in your trust. And so it allows for a relatively seamless transition, when you die, passing property on to people you love and holding on to that property for their protection so that they can, acquire it by the time they're responsible, by the time they're old enough, or if they have a disability, someone else can just take care of them. They can stand in your shoes and take care of the people just as you would have had you, lived long enough.
Well, you know what I don't get is if I have a will, I designate who gets what and where it goes and who I don't want to get anything. Why am I going to court?
Yeah, well, so there can be all sorts of opportunities for abuse. And so one of the main things that the court does is make sure that the will is done correctly, that there are witnesses, that the person who did put the will together had the mental capacity to put that will together. And so there's this check to make sure that all of this was done correctly. Probate actually is Latin for proving a will. And so that's really the whole thrust, the whole point of the process is just to prove that it was done correctly. And once that's proven, then the court, and if you've named an executor, then the court says, oh, okay, this is someone you've articulated as someone trustworthy. We now will let you kind of move on with this process. So it offers a nice check.
So even if does your will stay valid after a divorce? If you do your will before a divorce, does it stay in place until you redo it?
Well, so it stays in place, but for any gifts or bequests to your ex. And so that could lead to some, benefits, right? If you didn't have the intention to leave anything to your ex, then great. But there could be a lot of confusion as well, because, well, then where does it go? Maybe you didn't say who it's going to go to, or maybe you named your ex as the trustee or the executor, and now who's going to be that person? And so
it would still be valid, wouldn't it?
The will would be valid, but the naming of the ex is essentially ignored.
Really? So if it says that Ralph is the executor and I die and Ralph's still around, I mean, wouldn't he still be the executor?
Well, so it's treated as though he died before you.
Really?
Yeah.
Yeah, that's what's my understanding, that wills have to be redone after your dissolution, or you may end up thinking you have a will, but you don't.
Right. Or it's just going to lead to a whole bunch of confusion, because there's essentially two documents now. There's the divorce decree. There's like the, what came out of your divorce. And then there's your will, and they don't agree with one another. And so some people might think, well, gosh, the will said I'm supposed to get X, Y, and Z. And meanwhile, there's this divorce decree that frankly overrides what that will said. And it can create a whole bunch of confusion, and it's created a whole bunch of litigation. And there's a whole bunch of case law out there that, is the outcome of that litigation. But, you could do your family a big favor by updating that estate plan after a divorce, so that you save a lot of that confusion. So I have some questions for you, because I know, I see a lot of clients, maybe before a divorce or after a divorce. What are some fears or concerns that clients have when they come see you and approach you contemplating a divorce?
As it relates to your area of law?
Well, or as it relates to family harmony or taking care of the kids or things like that.
Yeah. I mean, I think I see a common provision all the time that they want, which is if I die, I want somebody else to be the custodian of the children besides the dad.
Yeah.
It's a hard one.
Mm-hmm.
Yeah.
Right.
But mostly when I talk to people about, estate planning and how important it is, it's almost like you're dancing on their grave, and they're like, well, we'll just talk about this later. And I'm like, no, like it's important to talk about it now, because anything could happen at any time.
You know what I see happen is people want life insurance is a big issue when they're getting divorced. They want life insurance to protect, whether it be, maintenance or more likely child support. And they always want to name a child as the beneficiary on a life insurance policy.
Problem, yeah.
Yeah, and it seems, and I'm always advising them to talk with someone like yourself to look at a life insurance trust. Can you talk about that? I mean, does that make sense?
That makes perfect sense. So what Jan and Kim are talking about, and I love that you talk about this with your clients, because this is so important. And I often see this get messed up by family law attorneys. My clients who will have just finished a divorce come see me, and they'll have their settlement agreement that says, you got to name the children as the beneficiaries. And I think they're kids. They can't inherit.
It's a mistake. Yeah.
Yeah, they can't inherit this money. Or sometimes it'll say, to my ex for the benefit of the children. And that's a little better in some respects, because, these kids aren't going to be inheriting this money. But what you're creating is a really vague trust with no instructions and very little check on this person that you've pretty much established you don't trust anymore and you don't want to be entangled with anymore. And now suddenly they're going to be the ones taking ownership of all this money that was supposed to be for the people you probably love the most, which are your children. And so setting up this trust is a beautiful option when it comes to life insurance, because now you are creating this team that's going to be in place to take care of your kids. That's not your ex. And you can say, look, I want my brother Jim or my friend Amanda, and they're going to be the one who's in charge of making sure the policies continue to get paid, or making sure, if you were to become disabled, let's say, or making sure that your children get the benefits of those assets, even if they're young. If I were to die and I set up a trust like this for the benefit of my children, and my children are young, my trustee could instead of giving all that money to them, upon their turning 18, can make sure their college education is paid for, or can make sure that their health needs are addressed, or maybe, help them with a down payment on their house, but do kinds of the same things that I would have done had I been alive, without me worrying, is my ex going to do the right thing? Are they going to squander it? Are they going to spend it on?
How do you know that whoever you've designated is going to do the right thing?
That's a great question. So, you have the authority to choose someone that you trust the most. And so ideally, you have someone in your life who you do trust. There are some safety mechanisms that you can put in place. So there are somebody called a trust protector that you can add to your trust, essentially whose job it is to oversee the trustee. If that trustee goes rogue, they can simply remove the trustee, replace it with somebody else. You can name a corporate trustee whose job it is day in and day out to do these kinds of things.
What does that cost?
That's a great question. It varies from company to company, but it's roughly about 1% of the value of the trust. So if you have a trust.
Well, let's say it's a life insurance trust, which means it's unfunded, right, till you die.
Right. And so if it's a life insurance trust where, there's a couple different ways you can do it. One is you can set up a life insurance trust during your life where the trust owns the policy. And the job of the trustee is to make sure that the premiums get paid on an annual basis. And so that task of monitoring the trust and making sure that the premiums get paid, has some value. It's not very time consuming. And so in terms of cost, that would be relatively nominal. But upon death, once it does get funded, then it, depending upon what the life insurance benefit is, maybe it's $1 million, maybe it's $2 million, maybe it's $5 million. And if these trustees are then holding and managing these funds now for the benefit of, let's say, minor children, there is some real work to be doing in terms of making sure it's appropriately invested, making sure that distributions are made correctly, making sure that they're accounting for the expenses and distributions, et cetera. So that 1% does become pretty relevant there, and does, it's pretty consistent with what a financial advisor might charge or something like that as well.
And what I find is if you have a divorcing parents and they're going to get a life insurance policy, the other parent's like, no, I don't want your Uncle Jim or your sister Sue. It's got to be me. I want to be the trustee when you die. So we run into that a lot. So how do we draft something to make sure that we're comfortable with it? Is it just going to an estate planner like yourself and agreeing on these terms?
Yeah, that's a great question. So, one thing you could do is bring an estate planner into the conversation, and they can kind of explain the different options. And, if the ex wants to be the trustee, we can try to find out, why, like, what is the concern, and really get at the root cause of that concern. If there's a fear of abuse, maybe they could be a co-trustee, or maybe they could name name a relative as a co-trustee so that there could be that check, or maybe they could receive mandatory accountings so that they could at least have some oversight. But we could kind of get at what it is that's causing them that concern, so that there could be some mutual meeting of the minds and coming together. And
well, the issue is going to be, frankly, if whoever she's chosen to be the beneficiary hates the ex-husband, right? Then when the ex-husband needs something, he's going to have trouble getting it from this guy because this guy hates him. That's going to be the issue. Like, pick somebody I can talk to.
Right. Yeah. So maybe there's like maybe there's a brother or a cousin or something where the relationship isn't so divisive, and that person can be the trustee, someone who is a little more neutral, who they can both agree on is going to follow the instructions of the trust and exercise any discretion they have in a way that's fair and that reflects the terms of the trust, because the trustee is required to follow the instructions. And if the instructions are, my ex needs to get X amount of money each month, they have to follow those instructions.
I say, forget about the children for now. I want to know about the trust for pets.
Yeah, well, great question.
It's all of the rage I hear.
Are you hearing that a lot?
Yeah, it's not true.
No, I mean, I get it frequently, but I wasn't aware that it came up a lot in the divorce context.
Pet custody is like something all the time that people, I can't tell you how many requests for information we get, forgetting about a divorce even, just like, my boyfriend stole my cat, what do I do, And so, yeah, and there's certain animals, like, I know, like, I've had koi fish in the past that live, like, longer than me. Certain birds will live longer than you, but like, if your dog dies, I mean, I've heard that people have trust to take care of those animals.
Yeah. So you can, I've put together a few pet trusts, and we name, who's going to be in charge of caring for the pet, who's going to be in charge of overseeing the money for the pet. Sometimes those are the same people, sometimes they're not. We talk about, we live in a very global society, or we did up until we're on lockdown now. But we talk about, like, who's going to, ship the pet to California or to New York or internationally, and will the costs of that shipment be included in this gift that we're making from our estate on our death? And so it's, it can be very complex, and it feels, it feels silly, but gosh,
I do not think it's silly. Jan, on the other hand, look at her face.
Jan, do you have any pets?
No.
Kim, do you?
I have 2 dogs in Mexico now.
Oh my God, they're in Mexico.
Yeah.
Okay. So all about shipping international.
No, they stay there. I'm the one that goes back and forth. But,
yeah.
But, I entrust somebody there, to take care of them when I'm not there.
Yeah.
Although I have not provided for them in my will. So now what?
So you need an update.
What happens? Let's talk about that for a second. What happens if you have a will here in the United States and you have a home somewhere else? Let's say I have a home in Italy and I have pets in Italy and I want a new will to take care of my pets. If I do a new will in Italy, what happens to my will in US? Can I have 2?
So what I typically recommend is,
there's a question.
Yeah, I have made estate plans for clients out of the United States or who have dual citizenship. And we just make sure that the country with which they have dual citizenship is a signatory, has signed on to this treaty that recognizes international wills. And so we make sure that the will that we create aligns with that treaty so that it will be honored I just did one for Australia recently, and Australia is a signatory to this treaty. So we made sure that we could address her property in the United States as well as her property in Australia. I always tell my clients, you need to talk to an attorney in Australia or in Italy or in Mexico or Canada, because I can't really opine, with certainty. I can't give an opinion with certainty on what is the current state of the law in these countries. But a lot of countries, especially with, similar legal origins as the US. So if we're talking about legal origins like England, then Australia has very similar origins. They do recognize trusts. A lot of countries recognize trusts. And so if we're putting a trust together and we have this international will, there can be some coherence, right? Some overall consistency in the plan.
What if you have two, though? What if you have one here and one there? Does it have to be one international will, or can you have two wills?
Yeah, so usually when you put a new will together, it has the effect of revoking the old will. And so I would be very careful.
Really? Oh, no. I thought, because I was going to get a will in Mexico and here.
Yeah, so.
Where does my question come from?
Is that where it comes from?
I didn't know that it would revoke my will here if I did a will there.
Yeah, so you just want to be careful, and you can maybe specifically specify that you don't want to revoke your will here. So it essentially, instead of a will, it's really like a codicil, like an amendment to your will here. And same, if your will followed these international rules, which it probably did, whereby you had to witness.
Nicole drafted it.
I know it did, actually. I just didn't want to say it. It should be honored in Mexico as well. And so whatever you put together in Mexico, just make sure it includes those same requirements, those two witnesses, a notary, and you call it a codicil instead of a will. So it's like an amendment. And that way it won't revoke what you've put together here in the United States. But it definitely gets complex when you have properties outside of the US. It can get complex when you have properties outside of the state of Illinois. And these are all great reasons why you want to consult with an estate planning attorney.
And you want to consult with an estate planning attorney, like maybe even when you're talking about which assets are you going to get in the divorce, because does that make a difference on what assets you get and how you hold them?
Yeah, definitely. So, I'll often see things with, like with regard to real estate. And maybe you could share a little bit about some of the back and forth or the big drama behind which assets people might be fighting over in a divorce. And then I can talk about some of the issues that I see on my end.
Yeah, we have some questions here.
Well, a lot of that, though, I think is when you talk, of course, has their own set, but generally comes down to you can't really fight about a specific asset, or the court will say just sell it and divide the money. So really, I guess it comes down to if they can't agree on property issues like the car or the house or, this knickknack or this piece of bowl from China, then you gotta ask.
She's talking about my
court
bowl.
will probably likely have you sell it.
Yeah. Okay.
But, so anyway, there are.
I think we
There's
lost.
a question. What's the question? Is it for Nicole? I think we might have already answered it.
I lost you a little bit there, Jan. Kim, did you hear her?
No, you got all garbled, but she's saying, I think that this question may have been answered already, but because Melissa writes, I'm wanting to put a third party in charge of my estate for my daughter. Does the court uphold that request to care for the money for my daughter? My ex is in major credit card debt, school debt, business loan debt. I'm concerned if he had the access to the money, it's not going to be there for the child.
Yeah, that's a great question. So one of the things that when someone comes to see me post-divorce, and something that I know, Anderson and Boback does quite nicely is we always ask that to share the marital settlement agreement, share that divorce decree, so we can look at it and see closely what were the specific requirements of that marital settlement agreement. And if the agreement leaves open the possibility that you could add somebody as a third party to an asset, or another owner to the asset, well, then we've got some room to play around with. Ideally, it would be held in a trust for the benefit of the children. And most likely there is some wiggle room there in the marital settlement agreement to allow for that to happen. If there isn't, then maybe it's something that we could revise, make some revisions. Have you guys encountered any instances where a revision needed to be made, Kim or Jan?
Yeah, well, we're forgetting about even like a divorce. We had a couple that were still married, 2 kids, and she died. And then the life insurance was in the kids' names. And so he couldn't even cash the check.
Right.
He had to open up a probate estate for the children, and it was like such a hassle for him.
Yeah.
Whereas if she had just left him as the beneficiary instead of the children, it would have been so much cleaner. He could have got the check. He could have done what he needed to do. You wouldn't need a life insurance trust then, would you? I mean, if you're still married to each other.
No, and even if you're not still married, you don't need a life. You can just put together a living trust, and that living trust could be named as the beneficiary. And then you just name someone as a trustee of that trust to take care of those assets for the benefit of your children or whomever it is you want to benefit, your dog, your koi fish, upon death. So
your bull from China.
Exactly. Right. So
well, what happens when you get a divorce and there's this bull from China that I get to for 5 years, but then I have to turn it over to my husband. But then in the will, they leave it to somebody else. What if they don't match?
Yeah, so if they don't match, that's a great question. It leads to a lot of attorney fees.
So, more legal fees, right?
More legal fees, right? And so, a lot of people, I think, get scared about hiring an attorney because they feel like they're going to end up spending a lot of money, and they don't want to spend a lot of money. But in situations like you're explaining, Jan, you're going to spend a lot more money if you don't have it done right. And so it really highlights the importance of having a team together, having your family law attorneys and your estate planning attorneys talking to one another, and bringing your estate planning attorneys on board, or if you're talking to an estate planning attorney and saying, I'm thinking about getting a divorce, bring in some family law attorneys right then, so you can kind of have a team-centered approach to all of these things, so that we don't have a situation where we need to figure out, well, which overrides what, the will, the trust, or this, marital settlement agreement when it comes to Kim's beautiful bowl. Just, to come back to that.
I hope she leaves it to me.
Unless she leaves
it to you. I'm not leaving it to you, because you do not love it like I do.
Yeah. So, I don't know. I know that's probably a hard thing to talk to clients about, though. I imagine, do you guys have a challenge talking to clients about estate planning? I know, Kim, you mentioned that a little bit.
Yeah, frankly, I pick up the phone and I call you, or I have them call you, because
yeah, we don't give advice on estate planning because we certainly don't keep up with those rules, but we do know it's important. And and I think just from knowing and talking to you, if you don't have a estate plan, or you think you don't have an estate plan, you really do.
You really do. Well, exactly. It just might not be the one you want. And so
whatever the state says, right?
Exactly. And that usually ends up being the most expensive, because it always requires, going to court. It requires then posting a bond with the court, because you haven't gone through the trouble of naming someone you're essentially telling the court is trustworthy. And so they're going to require some sort of bond be paid to prove that up. There's filing fees. There's, of course, legal fees involved in all of that. So it makes sense to at least talk to somebody about this in advance so that it's not a hot mess,
What about if you have a trust and you, let's say, buy a house? I just simply add the house to the trust by a new document? Do I have to go see my estate planning attorney again? How does that work?
Yeah. So what I usually do is when I put my trusts together, I try to make them really broad in terms of the assets. That way my clients don't have to come see me every time they open up a new bank account or buy something. And so really what we're articulating is, okay, I want 50% of my assets going to my son and 50% of my assets going to my daughter, something like that. So we're not listing every asset in the trust. And then when we buy and sell things, we buy them in the name of our trust. So if I buy a new house, I'm going to buy it, in the Nicole Soltanzadeh Living Trust. And that way it's now subject to all the requirements of my trust. And I'll keep a record of that purchase in my portfolio so that now if I become disabled or if I die, whoever picks up my portfolio sees, oh, she owned this beautiful vacation home in Florida and she had this house in, Michigan and blah, blah, blah. And it's really nice and easy for somebody to pick up and see what she owned or he owned. And you as the person who created that trust, you don't have to go see your attorney every time you buy and sell something. So you buy and sell something in Illinois, you're talking to an attorney anyways, your real estate attorney, and they know enough to ask, hopefully, do you want to buy this in the name of your trust? And you do. And then it makes your life a lot easier down the line.
Yep. Our friend Keith is back. He comes every week, except for last week. I don't know where you were last week, Keith, but Keith has a question for you. He says he set up a trust for his kids 4 years ago and recently purchased a new home. I was told that I need to set up a codicil in order to determine my plans for the new home. Is that correct?
So
I don't know if I understand that.
Yeah. So a codicil is it's a word that it really just means an amendment to your will. And so if you have a trust and if you purchase this house in the trust, then maybe what you need to do is revisit your trust and look at it again and see, should you amend your trust?
Shouldn't you just put the house in the trust?
It depends on how his trust is worded. So if the trust is open and using percentages rather than saying, this person is getting this bank account and this person is getting this asset. So I'll sometimes see trusts written with very specific assets listed in the body of the trust. I hate when I get those, because usually when someone dies, they don't still have an account at, Fifth Third or MB because it's now gone, or they've, since moved their assets around. So if you've listed in this trust document, I want, my friend Jim to get my bank account at Bank of America, and there is no bank account at Bank of America. Well, now there's confusion, should Jim get something else then because now this gift is gone? No, that gift goes away, but your intentions maybe were to have Jim get the value of whatever was in that bank account. So it's important sorry, Keith, first of all, sorry, I can't answer your question as well as I would like to. I would want to see your trust document and see how is it written. And if it's written, more so with regards to percentages, then maybe what you just need to do is purchase this property in the name of the trust. If it's written with regards to very specific listings of properties, then maybe you need to do an amendment.
And it looks like
how can Keith reach you?
It sounds like he's already purchased the house, so he just needs to retitle it in the name of the trust, right?
Right. And so in that instance, he would essentially do a deed to himself as trustee of his trust and record that deed. And that's a bit of an annoying process, but I help clients with that all the time because especially if that's in Chicago, you need to get a full payment certificate from the city of Chicago. You need to fill out this declaration with the state of Illinois. There are some prerequisites to getting a deed recorded, but I work with clients all the time in doing that.
Do you want to give him your number, Nicole, so he can reach you afterwards?
Yeah, sure. Should I just say it out loud here? Or?
Why not?
773-917-4466. That's probably a lot, unless they can see the spelling of my name on here, probably.
Yeah, I can.
Yeah, you can. Okay. And so you can go to soltanzadelaw.com and you can get my email address, contact information if you'd rather just send me an email as well.
Because we'd rather you ask questions now than when it's too late.
Yes. Okay. I'm seeing questions pop up in this chat box. Do I?
Yeah, pick one.
I am meeting people remotely. So someone's asking whether I'm meeting people remotely. Yes, I would take COVID very seriously, and I take my health very seriously. And I know I want to take my clients' health very seriously as well. So we've really pivoted in this COVID landscape, and I do all my meetings with clients over Zoom, except for when we need to sign estate planning documents. And I do have a nice setup on my back, in the back of my house. So we have on my back deck a table set up. We, set out hand sanitizer, masks, the works. We all wear masks, and we do the signings of the estate plans in person. Those still do have to be done in person. If the weather is not nice, we do curbside signings. So you simply drive.
Do you ever go to their house?
So I tend to avoid going to clients' houses just for the safety of myself and my associates. But if it's somebody who I have a relationship with, or if there's an urgent need, I can, but it would, again, it would need to be done outside, just because of this new world that we're living in right now.
That's great information. A lot of stuff going on when you're getting a divorce. Estate planning is a big piece of it. Thanks for joining us. We really appreciate it, and really appreciate all the information.
Thank you so much for having me. I really enjoyed being on here. You guys are just wonderful to spend my afternoon with. I feel like it was a bright spot in my day. So
nobody ever says that.
Oh, it's the truth, though. Yeah.
Really good to see you. Really good to see you. And until we can meet you again in person, be well.